Good afternoon, everyone, and welcome to our webinar today on the 50th anniversary of the Rehabilitation Act. We will get started momentarily. Well, again, good afternoon, everyone. My name is Heather Ansley, and I'm the Chief Policy Officer here at Paralyzed Veterans of America. We want to thank you today for joining us for celebrating 50 years of disability rights and the Rehabilitation Act with our presenter, Danica Gonzalves, who is our advocacy attorney here at PVA. Next slide, please. So before we dive into today's content, we just want to go over our webinar process for everyone. So first off, the webinar is being recorded today, and it will be available for viewing later on pva.org. We also have closed captioning available, so please click the CC button in the meeting controls bar at the bottom of your screen to turn that on. Also, if you have a question, please do use the Q&A box that's in your control bar, and we will take questions at the end of today's program. So again, please use the Q&A box in your control bar to ask any questions that you might have. And with that, I'm going to go on and turn it over to today's presenter, Danica.
Hi, everyone. My name is Danica Gonzalves. I'm the advocacy attorney here at Paralyzed Veterans of America. Today, I want to speak with you about the Rehabilitation Act of 1973. The 50th year anniversary was on Monday, September 26th, and this was a monumental law that really did shape disability rights, disability discrimination protection, and the disability rights movement as we know it today. So we are going to go through the different sections of the Rehabilitation Act, how it compares against the Americans with Disabilities Act and also the Architectural Barriers Act, the movement behind disability rights, and how we were able to get the protections under the different sections, including Section 504, which protects against disability discrimination in federal programs and activities, Section 508, which is technology, specifically information and communication technology, employment by federal agencies, employment by federal contractors, and how you would go about filing a complaint if you feel that any of your rights were violated under the Rehabilitation Act. As Heather said, if you do have any questions, please place them in the Q&A, and we will answer those questions at the end of the presentation. So first, we are going to start with just the basis of the Rehabilitation Act. So this was a federal law that prohibited the exclusion or denial of individuals with disabilities from equal opportunity to participate in any benefits, services, programs, activities, technology, or employment by the federal government. So this applies to federal agencies or federally funded programs, activities, services, technology, or employment. And that does include the Department of Veterans Affairs, the VA, Department of Defense, National Parks, Department of Housing and Urban Development, Department of Health and Human Services, and any of their federal contractors that are funded by any of these agencies. It is broken down into different sections that cover the non-discrimination requirements under that specific section, and this would be whether it was technology, a service, and also what entity may have done the discrimination under for employment. So the Rehabilitation Act was passed before the Americans with Disabilities Act. The Americans with Disabilities Act was passed in 1990, and it is important to recognize the differences between the two laws. So as we were talking about, the Rehabilitation Act applies to those federal agencies and federally funded programs. The Americans with Disabilities Act, in contrast, applies to state and local governments. So that would be the services, activities, programs that they run through the state and local jurisdictions, and also the places of public accommodation. These are private businesses that are open to the public that provide goods and services, including hotels, stores, etc. But we are going to be focusing today on the Rehabilitation Act. And once again, that is for federal or federally funded programs, activities, technology, or employment. There may be situations when an entity would need to comply with both the Americans with Disabilities Act and also the Rehabilitation Act. This would be when a state or local government or a private place of accommodation receives federal funding. For example, if you have a large apartment building that falls under the places of public accommodation, but they also do receive some federal funding, whether that be through a housing choice voucher that is federally funded, then both of these laws would apply and they need to comply with the anti-discrimination requirements under both laws. But today we are going to focus on the Rehabilitation Act. I did just want to bring up that there may be situations where both laws may apply to an entity. There is also a law called the Architectural Barriers Act. So the Rehabilitation Act does not actually apply to the facility itself. For example, if you go to a VA health center and there is a physical barrier that is causing the access to be blocked, the Rehabilitation Act does not actually apply to the facility. That instead is covered under the Architectural Barriers Act, which was passed in 1968. So the Architectural Barriers Act applies to the facilities that are designed, built, altered, or leased with federal funds. When a building was built before 1968, it is exempt from the Architectural Barriers Act requirements. But if they altered the facility in any way, those altered portions would be then required to comply with the Architectural Barriers Act. When the Rehabilitation Act was passed, like I said, we have the different sections. Section 502 created what is now known as the U.S. Access Board. The U.S. Access Board creates and issues the requirements for physical access under the Architectural Barriers Act. They also do issue guidance and other type of accessibility standards that then the Department of Justice or Department of Transportation may use as the basis for their standards. And we will talk about how to file a complaint under the Architectural Barriers Act. But today, because of the 50th anniversary, we are going to be focusing on those requirements under the Rehabilitation Act. So Section 504 of the Rehabilitation Act prohibits discrimination in any federal or federally funded program or activity. This would be essentially any service, program, benefit that the federal government offers or funds. The term that they do use in the law itself is this phrase called program or activity. but you can define that and expand that to any service. Examples of a Section 504 entity would be VA healthcare services, because this is a service that a federal agency does provide. Also, as we discussed earlier, housing may be covered under Section 504 when it is federally funded or if a federal agency provides that housing. Other types of programs or activities under Section 504 would be any recreation opportunities. This could be at a national park, at a national forest, at a national memorial, any type of service or activity or program that the federal government provides, that would be covered under Section 504. So as we're saying, Section 504 means they cannot discriminate against individuals with disabilities. They cannot have any type of inaccessibility for that service. We'll talk about some types of Section 504 violations, but it's really important to understand the history behind Section 504. There were demonstrations over Section 504 back in the 70s. As we talked about, the Rehabilitation Act was passed in 1973, but part of the law required the Secretary of the Department of Health, Education, and Welfare to pass regulations about how to apply and enforce Section 504. This meant the Secretary needed to define who qualifies as an individual with a disability. What is disability discrimination? And it fell on the Secretary to make these regulations. But 4 years later, regulations were still not in effect. Nothing had been issued. And this caused disability advocates to come together in April 1977, and they arranged sit-ins at federal buildings. And there was one in the San Francisco federal building that lasted for 26 days. I'm gonna play a video of this sit-in because it's really important to see how advocacy can push and encourage and pressure the government to act.
Well, Isabel, what's going on now is an overnight sit-in. Actually, the demonstration is going on throughout the entire nation: Washington, New York, Denver, here in San Francisco. It all started this morning here at the old Federal Building on 50 Fulton when an incident took place outside. Immediately after that demonstration this morning, the handicapped started invading the building. It's the old Federal Building, which is now the HEW headquarters. They spent most of the day in the office of the regional director here.
Gotten word to that these people are now locked into the building. At 6 o'clock, this building did close down. However, about a half hour ago, they came up with an agreement. None of these people are going to be arrested or moved out of this building. Some members of the HEW staff will be remaining here with them throughout the night. Those people who are here right now will be locked in. If they want to leave, it's all right, but they can't come back in. Food, we hear, is being brought over by Delancey Street. However, the Salvation Army has not been able to come up with blankets or cots, that sort of thing, so they are still frantically out looking for that.
What about the restroom facilities and that sort of thing there? Are they equipped to handle that many handicapped people, and could they get that help?
They absolutely are not equipped to handle them. The regional director asked before 4 o'clock if he could try to get out of this room because he needed to go to the restroom. And the group here said, no, we have had to learn all of our lives to control our bladders, and you must learn that lesson now, too.
There are approximately 75 or more who are taking part in this sit-in. This makes this the largest sit-in in the nation currently going on concerning the disabled and the handicapped. In Washington, there are about 40 people sitting in the outer office of the HEW Secretary, Joe Califano, and there are about 7 people in New York.
98 people stayed overnight in the offices used by Regional HEW Director Joe Maldonado. The 50 who remain at this hour say they have no intention of leaving until
There are people that want to stay here until, and there is a significant number of those people.
Quite frankly, I think it's going to be very difficult for them to put a lot of pressure on us. When we asked them questions yesterday about 504, and we said to them, have you ever read 504? Every one of the people that we had in that office said no. I mean, I think that they should thank us for being here and welcome the opportunity that finally they're going to get educated about the law that they're supposed to be enforcing.
This is a great example of how advocacy can pressure governments, agencies, and entities to move forward with the promises or even create new laws that allow protections and increase protections for people with disabilities. It took 4 years for those regulations to be signed about how Section 504 would be interpreted and enforced. And it was due to this large demonstration. This demonstration in San Francisco lasted 26 days. The people there were not able to leave. If they left, they were not going to be able to come back in. And for 26 days, they slept there. They had to avoid going to the restroom because, as they said, the restrooms were not accessible, and really put pressure on the government and secretary to sign those regulations so that they could have their rights. Part of Section 504 requires the federal entities or federally funded programs and activities to provide something called reasonable accommodations. When a program, service, activity is inaccessible, they need to provide some sort of reasonable accommodations so that a person with a disability can access that service. A reasonable accommodation is any change, adaptation, modification to a policy, program, or service that allows a person with a disability to fully participate in that program, activity, or service. We were talking about before a physical barrier that may exclude a person with a disability from accessing a specific service. If that barrier cannot be removed, then the entity is going to have to provide some sort of reasonable accommodation so a person can still access that service, whether that be they move the activity or service to a different location that is accessible, whether they maybe move it so there is an online application, but they can't, under the Rehabilitation Act, exclude or deny people with disabilities from the program's activities and services. There is one exception, though, to the reasonable accommodations, and that is if it would cause an undue financial or administrative burden on the entity or result in a fundamental alteration of the program, activity, or service. There are times where it may require a complete overhaul of the service in order to make it accessible. If it is a recreation opportunity that is not accessible because of the nature of the recreation activity, then the entity will be able to say, in order to make this accessible, it would require a fundamental alteration of the activity, and they do have that affirmative defense. But it is a very high bar to show that exception. Often, they are going to need to provide the reasonable accommodation, and it is the right of a person with a disability to ask for a reasonable accommodation when something is inaccessible. There are different types of violations of Section 504. The basis of 504 is a federal agency or federally funded service cannot exclude or deny a person with disabilities equal opportunity to benefit from that program or activity. These are just a few examples of what could be a Section 504 violation. That would include straight up denying a person with a disability the right to participate in a federal program or service. If a wheelchair user goes to a national park and they say, no, we do not allow wheelchair users to come into the park. That would be an example of denial of access to an activity or program, and that could result in a Section 504 violation. Another 504 violation would be failure to provide those reasonable accommodations. As we were talking about, if a service is in an inaccessible building, they need to provide an alternate way to access that service and provide that reasonable accommodation. The exception would be if it would be an undue burden, financial burden, administrative burden, or result in that fundamental alteration. If they do give a reasonable accommodation, but it results in a service that is not equal to the service that people without disabilities can access, that also is a Section 504 violation, because Section 504 requires equal opportunity to participate. They also cannot deny a person with a disability from serving on an advisory board. This is significant because it allows individuals to be on those advisory boards to make sure their voices are heard, and they can't deny this right to be on an advisory board. They also can't limit a person with a disability's right to enjoy the activity. For example, they can't give you a portion of access to a service or result in any type of harassment or retaliation because of your disability. So that would fall under limiting your right to enjoy an activity. The next major section of the Rehabilitation Act, and this is really a hot topic right now in legislation and hearings and also complaints at agencies, is Section 508. This applies to electronic technology. The exact phrase used in the law is information and communication technology, or ICT. And this would be any technology that the federal agency develops, procures, meaning purchases, maintains, or even uses. This ICT phrase applies to electronic devices, kiosks, transaction machines, websites, mobile apps, electronic documents, computer software, any type of technology that either a federal employee or federal contract employee or the public needs to access falls under Section 508. We had PVA filed a complaint under Section 508 over the Department of Homeland Security's global entry kiosks. These are the kiosks they use for passport control when someone is coming back into the United States after an international trip. The kiosk was not accessible. The kiosk does fall under the definition of ICT, and PVA filed a Section 508 complaint. Due to this complaint, the airports are now replacing or retrofitting their kiosks so that they are accessible. And this is why complaints are so important. We talk about filing complaints because this is the way to result in change. We watched the demonstration that was advocacy to push a federal agency to act and sign and enforce Section 504. Another way to have these agencies act is to file complaints. Complaints is advocacy. So we really want to make sure that we are moving forward and doing the things that we can do in order to advocate and enforce the Rehabilitation Act. There also still is that exception, like 504, if making the information and communication technology is an undue burden, the agency may have to provide essentially reasonable accommodations or alternative means of access. But due to COVID, Section 508 was highlighted. A lot of services, especially federal agency services, were moved electronically. They started being offered online or started using kiosks and other types of devices to reduce human contact. During this change, it became very prevalent how inaccessible these devices and websites are. This is causing a lot of movement under Section 508, a lot of scrutiny under Section 508. So filing Section 508 complaints is also very, very important as the government is scrutinizing and looking at the enforcement and also the application of this law in the agencies. There are a couple other sections we will talk about. One of them is Section 501. And this applies to federal agency employment. And that is going to look at disability discrimination by the federal agencies if an individual with a disability specifically works for the federal agency. Federal agencies, just like other employers, are prohibited from discriminating against an individual because of their disability. This includes in hiring processes, promoting, advancing, training, or even the federal benefits and employment benefits that they offer. In federal agency employment, they need to give reasonable accommodations if needed during any of these processes, including during the hiring, like the interviewing and applying process if needed. A reasonable accommodation in employment would be a change in the work environment. For example, if an individual that uses a wheelchair needs a ramp in order to access the building itself, and there's not currently a ramp there, that would be a reasonable accommodation to the work environment. It also can be a change in the way things are customarily done, so a person can have those equal employment opportunities. Another important thing under Section 501 is that the federal agencies must actively hire, promote, train, advance people with disabilities in employment. So there also is that requirement, and currently the agencies and administration are pushing for this to actually occur. Though this has been a requirement for a very long time, the employment rates of people with disabilities in agencies is still very low and is not even equal to the amount of people in the United States that have disabilities. So there has been a big push, especially recently, to have this requirement met of hiring, training, and advancing people with disabilities in federal agency employment. So there also is a similar section that applies to federal contractors' employment, and that falls under Section 503. The reason why it's important to recognize the distinction between the two sections comes down to when you're going to file a complaint, because the way to file a complaint under the two different sections is different, and that's why they are broken out separately. But similarly, like Section 501, federal contractors also cannot discriminate against a person with a disability in that hiring process, promoting process, training, advancing, or any of those portions of an equal opportunity for employment. Federal contractors must also provide those same types of reasonable accommodations during any of the employment processes, and they also must take those affirmative actions to hire, place, and advance individuals with disabilities in the employment sector. Examples of employment discrimination would be failure to provide those reasonable accommodations. If an individual ever needs a reasonable accommodation in any of those processes for employment, it should and usually does need to be submitted in writing. So if you ever need a reasonable accommodation, submit a request in writing for that accommodation. The agencies and the contractors can also not fire or harass an employee because of their disability. They can't give an individual unequal pay or benefits because of their disability. They can't refuse to advance or train an employee because of their disability. And importantly, the agencies and contractors cannot request an applicant or an employee to provide medical information or physical capability information. There is an exception if this information, specifically the physical capability information, is needed in order to perform the job itself, and a reasonable accommodation would not allow an applicant or an employee to perform that position. But generally, they cannot request this information from an applicant or an employee with a disability. So if you have a disability and you are applying for a job, or your employer comes to you and they are a federal agency or a federal contractor and they ask this information, this may be a violation of your rights under the Rehabilitation Act. Advocacy is very, very important. Advocacy and complaints are what lead to enforcement of the Rehabilitation Act. The individuals that participated in the sit-in in 1977, they were advocates, and they needed to just even have these regulations created and enforced. Now that we have these regulations, the agencies need to enforce them. The laws need to be enforced. And the only way that enforcement is going to happen is if a complaint is filed. If you are looking at filing a complaint or in the process of filing a complaint, it is always important to document the discrimination. After any type of incident happens, after you experience any type of barrier, write down the details of that incident, what occurred, dates and times, any people involved, the facility. These are often questions that are asked during the complaint process, whether it is on online or physical or written form. This information is very important. So right after the incident, write the information down, and that way you can provide it when you go to file a complaint. Also, try to obtain any type of evidence. With anything legal, evidence is necessary. Though they will have to still investigate just based on allegations, evidence shows that something happens. If possible, try to retain any type of emails that show discrimination, any letters, or if it is a physical barrier or any type of inaccessibility that you can capture, take a photo so you can provide that evidence when you file a complaint. The different sections and the different agencies have different methods and manners for filing complaints. So it's really important to check under that section and under that agency how to file a complaint specifically of that type. PVA will be posting an FAQ that has 5 major agencies under these 4 sections we talked about today, and how to file a complaint under those sections, because each of the agencies does have a different way, and each of the sections has a different manner in how to file a complaint. There are filing deadlines for some of these complaints. It is very important to meet these filing deadlines. Some of the filing deadlines, if you miss the deadline, you don't have a complaint to file, or you cannot proceed with the complaint process. Always pay attention to these deadlines. And if you decide to file a complaint, keep a copy of everything. Keep a copy of your complaint. If you file online, print a copy of the complaint and make sure that you keep any of those relevant documents. If you file a complaint via mail, never send the originals. Make a copy, send and mail the copies, but always make sure that you're retaining all those documents for your records. So Section 504, as we talked about, is the exclusion, denial, or unequal access to those federal or federally funded programs, activities, or services. If a person with a disability is excluded from participating, if they're given unequal services or programs, if they are limited in their participation of a service or program, if the entity doesn't provide the reasonable accommodations so the person can fully participate in the program. These would be those Section 504 potential violations. How to file a Section 504 complaint depends on the agency. We have the links to the different agencies. We pick some 5 of the top agencies that a complaint may be filed against. Each of these agencies may have a different way. Right now, a lot of the agencies, if that even is a way that you can file with them, do want those online complaints. That is for a faster processing. Some of the agencies you can't even file online, but generally it is going to be either an online complaint, emailed, mailed, or some even still accept fax complaints. But it's really important to look specifically how a complaint is filed with each agency, who the complaint is sent to, what office the complaint is sent to, etc. There is a link as well for the current agency contacts for Section 504. And if you ever need help filing a 504 complaint, you can contact the Department of Justice Civil Rights Division. The Department of Justice does not enforce Section 504, but they do have this helpline that will go through who to file a complaint to and how to file a complaint for against that agency. The Section 504 does not apply to the facility itself. We talked about how the Architectural Barriers Act does apply to the physical structure of a facility or a building. You can also file an Architectural Barriers Act if you come to a physical structure that is inaccessible. Those are always filed with the Access Board. The Access Board creates the standards under the Architectural Barriers Act, and any complaint would go straight to the Access Board. It is recommended to file online, and they do also have an email address and a phone number if you need assistance with that filing. Section 508, with the technology, with the move towards doing things online or using a kiosk for services, is becoming the new topic that is hotly debated and being enforced. Those also have a completely different process and under some agencies for filing complaints. This is why we talked about reviewing how to file a complaint with that agency, because each agency has their own way they want complaints filed, even under the different sections of the Rehabilitation Act. We included links on how to file with those agencies, but if you find that a kiosk at a VA is not accessible, this could be a Section 508 complaint. If the agency has a PDF that isn't used for an application from sort of benefit and that is inaccessible, this could be a Section 508 complaint. That is why these complaints need to be filed. If there is no complaint, then the agency might not even know is inaccessible, but through complaints, that is how enforcement happens. If there is any type of discrimination through employment with the federal agency itself, Section 501 complaint is filed. With the Section 501 complaints, there is not a cookie cutter way that a Section 501 complaint is processed. It first needs to go to the Equal Employment Opportunity Counselor for that agency specifically. The EEOC, or Equal Employment Opportunity Commission, does have a online resource that outlines all the steps, but it is a completely internal agency process at first when this type of complaint is filed. So take a look at that if that's the type of complaint you think needs to be filed. And ultimately, if the agency does not make a decision in your favor, you can then go to the EEOC. Section 503, all of those complaints are actually filed with a single office, and that's the Office of Federal Contractor Compliance Programs. Those complaints need to be filed within 45 days. So as we were talking about, you really need to pay attention to those filing deadlines, and more information can be found with the links. So we are going to move into our Q&A section. And I will turn it over to Heather to moderate.
Well, thank you, Danica, for walking us through the Rehabilitation Act. And I think as everyone can see, this is a, it was really a groundbreaking opportunity for disability rights access. PVA, went to court and used that law to try to push access forward in a variety of ways. So it really has been something that has been key to us over the years. So if you have questions, again, you have a Q&A box that is in the bottom of your screen, and you can use that to provide us with any questions that you might have about a particular issue. So to kick us off, one question I have, Danica, is how do you kind of navigate when a particular area is covered by a bunch of different agencies? So let's say they get money under the federal government, so it's a it's a 504 situation, but they also are a local government. There's a local government component, so the Americans with Disabilities Act also complies, and maybe there's a state law that complies. So there might be a lot of different laws that are supposed to mean disability access, and yet we've got a problem. How can people navigate and try to figure out what the best way to go is?
My advice would always be file with everyone. If they have all these different agencies or different federal rules that apply. For example, if it is a Section 504 complaint, let's say it is a housing provider and they need to comply with Section 504 because they received the federal funding. They also are a business open to the public and have those ADA requirements. And then there may be state laws that have disability requirements. The agencies, for example, with the housing provider, that would be the Department of Housing and Urban Development. They can't enforce the state law. They can't necessarily enforce the ADA. So that is why it is important to file with every single office, because otherwise you're only going to get partial enforcement. And all enforcement needs to happen if all of these laws are being broken.
That's a really good point, Danica. And I know that it can be sometimes really difficult to understand what laws are in effect and what laws aren't, and what does that mean? What are some of the main areas that you feel like 504 and other particular sections have been really critical in helping to make a difference in terms of improving access for people with disabilities?
Right now, there are a couple agencies that are reviewing their 504 requirements. And this is very important. This law passed in 1973. As far as the 504, a lot of those regulations didn't come into effect until we had this major sit-in 1977. But these were all in the 70s. We're now in 2023. Things have changed, programs have changed, even the name Department Health, Education, Welfare, that's not even the same office anymore. And the agencies, specifically Department of Health and Human Services and the Department of Housing and Urban Development, they're looking now at their 504 requirements and saying, this has been decades ago since these laws passed. Do we need to now maybe consider redefining some of the terms that we have in our law? Do we need to consider relooking at the specific requirements? Healthcare is a major issue because a lot of our members specifically, they receive healthcare from the Department of Veterans Affairs, or they may go to a provider and use Medicare or even a VA voucher to go to a community provider. Healthcare has been inaccessible for wheelchair users, especially even the basics of medical equipment like exam tables, the chairs, the equipment. Those have been inaccessible for wheelchair users. So a lot of attention is being put on how do we make this basic medical equipment accessible. Those are probably the two major agencies that are actually moving forward right now on the 504 requirements. These are all in proposals for rulemaking. We do not know where rulemaking is actually going to go. We don't know if rulemaking is going to be finalized, but right now we are working on submitting comments for the Department of Health and Human Services that does have this notice of proposed rulemaking. At this very moment, the comments are opened on how to redefine their version of 504. It is important for advocates to be involved. Advocacy is in how changes come about. Section 504 is explicitly about protecting people with disabilities. So disability rights advocates, people with disabilities need to raise their voices during this time because we haven't had this opportunity in decades to be heard. At this very moment is when we can voice our concerns, when we can say, this is where this needs to go. These are the requirements that need to be in effect so that protection is enforced. For one, we need to have enforcement of what currently exists, but also increased so that people with disabilities can fully and equally participate in these benefits and services.
Yeah, that's very important that people participate in advocacy. As you're correct, Danica, as we saw, the 504 regulations had to be pushed by disability advocates to get those out. And we do have some important rulemakings that are out right now that PDA will be commenting on and, you know, sharing what we hope will be included in the rules. One of the questions that we got was about, you know, this applies to, you know, a federal agency or if there's federal funds involved. And sometimes you might be able to tell, okay, it's probably federal funding that this entity got, but other times it may be harder to figure out, you know, well, do they get federal funding? I know that there's a website, usaspending.gov, that provides information about who gets federal funds. But can you tell me any more about that? And, you know, again, how do you find out if this entity is going to have a 504 requirement in addition to an ADA requirement?
It is important to distinguish how the federal funds come in. There are some entities that receive federal funds, but this has to be a federally funded service. So if they receive federal funds for something unrelated to the service you're trying to access, that wouldn't put them for this specific service to fall under Section 504. Often, federal agencies need to be transparent on who they are giving funds to. For example, the Department of Transportation right now is giving out a lot of grants to transit authorities in order to push programs or services or increase paratransit or other types of options with people for people with disabilities. All of this is on the Department of Transportation's website. They list every single agency or transit company or transit authority that they are giving money to, and also what they are giving money to. There has been a very large push, especially in more recent years, for transparency, including in funding. You can also check the program's website to see if they are receiving federal funding. There are some times where you can know just on the fact of what you're using to access the service. If you are using Medicare, which is federally funded, to go to a provider, you know that they're receiving federal funding because it is coming through you as a patient there. If you're using some type of VA grant to access a service, those are federal funds that are going to the entity for that service. So there are some times where it is apparent. Other times there might need to be a little more research that needs to be done. We here at PVA are a resource. I will give my contact information towards the end of this, but if you have a question of whether or not this entity receives federal funding, we are also a resource here to determine what laws may apply to that entity.
Well, and thanks, Danica. And many times, because multiple laws may apply, it can be good to see, like an entity you may know for sure is covered by the ADA. But you may want, and although enforcement is fairly similar, you may also want to know about 504 or, other laws, but certainly it can be helpful if you're in a situation where the ADA doesn't apply, if now 504 is an opportunity. Here's a question about, so if you're filing a complaint on a city department, like for pedestrian signals that are not accessible for individuals who are blind or low vision. I think of this as like the good old law school exam question. Tell us which laws might apply in that situation.
On the face, it would be an ADA violation, because the ADA does apply to those state and local governments. So since this is a city department, this would be an ADA complaint. There could be times though where Section 5, like another Rehabilitation Act section, might sneak in there. For example, if the federal government decides to give this city department grant funding and continued grant funding to install and maintain accessible pedestrian signals, not necessarily aware of any type of example off the top of my head, could happen. A lot of grants are happening right now for infrastructure. So if they do receive those federal funds for those city pedestrian signals, then you might have a section that kicks in. Another thing that might be impacted, let's say a federal agency like Department of Transportation decides to fund this. Sometimes this actually does happen. The federal government will hire a federal contractor to help with installing those pedestrian signals. So if you are employed by a federal contractor to help install those pedestrian signals, then you may have that Section 503 complaint because you are being hired by a federal contractor. So those are the nuances, but there are some ways where the Rehabilitation Act might be able to weave into that situation.
And thank you, Danica. And also, of course, we might have some state or local laws that might even apply as well. So many times when you see, a lawsuit, for instance, you might see something that says that they're seeking relief, and it may list several different laws that they are alleging that have been violated. And that might be a situation that you would find here. I don't see any other questions for today, so I'm going to turn it back to you, Danica, just to close out your final slides.
I do want to provide my contact information. It's here on the screen. I serve as the advocacy attorney for PVA. As the advocacy attorney, I am here to help members, to help chapters with advocacy. If you need assistance determining whether the Rehabilitation Act applies in that situation, or want to know maybe even what type of complaint to file, that is why PVA is here, to help as advocates. But we need to be advocates. There is only one way that we can raise our voice, and that is through advocacy. Whether that be filing complaints, whether that be pushing for enforcement. People with disabilities, we need to raise our voices. We need to let the agencies know, or even just the government know, these rights are being violated. As we talked about, some of the agencies, including Department of Health and Human Services, is re-looking at their 504 requirements. when we have the opportunity, it's important to let our voices be heard on what we think needs to be changed in 504. We can't necessarily let the rules from the 70s stand as the status quo for 2023 and forward. When we have that opportunity, we need to raise our voices, whether it be through comments, whether it be through talking to local, federal offices. But often one of the main ways that we can promote enforcement is by filing those complaints. If you need any assistance, contact PVA. We are here to help. And I just want to thank everyone that came in today to learn about the Rehabilitation Act. It is not widely known like the Americans with Disabilities Act, but it does apply in a lot of settings. So having that knowledge will be a way to know how to help with advocacy and with enforcement. And we thank everyone for joining us today.